I was promising you the ethics panel. These are the folks who really know their stuff in helping lawyers do what they should do and helping make sure they don't get in trouble for doing things that they were supposed to do. And I think you're going to really enjoy it. So Heather, let me turn it over to you, and maybe you can introduce you and the panel. Thank you.
Wonderful. Thank you so much for having us. We're very excited to be here. My name is Heather Rosing. I'm the president and CEO of a local law firm, Kleindienst PC, and it's my pleasure to be your moderator today for On the Cutting Edge, Updates in Transactional Security Law Ethics. We will be with you for 75 minutes today, and I think you'll find it jam-packed with useful information. Please let me introduce the three panelists today. Actually, I have the pleasure and privilege of knowing each of them outside of today's presentation. They are amazing people and a wealth of knowledge. First, we have David McGowan. He is of counsel with Morrison & Foerster. David has a long and storied career, including as a professor. I will mention that he has a publication, which is something I would recommend to everybody, Developing Judgment About Practicing Law. It's an ethics casebook published by West. Dave is one of the most talented ethicists I know, along with the other two panelists. Thank you for being here today, Dave. Next, on my far left, we have Carol Buckner. Carol will be offering us today the in-house perspective. Carol is a partner and general counsel with Procopio, also a local law firm. Carol is one of the most prominent ethicists, I would say, in the country. I've known her for a long time. She's a prolific publisher herself. I've learned today she's published probably over 100 articles on ethics. She donates much of her time to speaking, teaching, and writing to groups such as yourself. And to my immediate left is John Vila. John is with Williams and Connolly. He joins us all the way from D.C. I imagine many of you probably have heard of John or know John. He has a nationwide profile in his areas of practice, which includes ethics and malpractice cases involving securities transactions. John is the author of a really amazing book, which I've had the pleasure of reading in part, Corporate Counsel Guidelines, published by West and the American Corporate Counsel Association. John also is an extremely talented ethicist, advising many law firms across the country on litigation and matters pertaining to ethics. I myself had the pleasure of going to Northwestern Law. I graduated in 1996. I feel like I've come home again, and I hope many of you also are graduates. If so, it's good to see you. So with that, we're going to launch into our program. This is how we're going to organize it. We have three different hypotheticals for you today. I'm going to briefly summarize the hypothetical for you, and then each of the panelists will take a lead on that particular segment. So 3 segments over our 75 minutes. So first, we have securities claims against lawyers, and John is going to be in charge of this section, and I'm going to tell you a little bit about the hypothetical. I'm not going to read it to you, but rather summarize it to you. And then we're going to generate discussion through John. John may ask some questions of the other panelists. I may ask some questions. And while we are not taking questions during this session, we do invite your questions after it's over. So this hypothetical deals with a company called Xerxes. It's a young, privately held real estate company, and it buys apartment buildings, rents the apartments. Once they're fully rented, it sells the apartment buildings into limited partnerships, or puts them into limited partnerships with Xerxes sells to investors. They claim enhanced profit margins because of unusually low tenant turnover. And they say that they have unusually low tenant turnover because they have a proprietary and confidential algorithm which allows them to identify prospective tenants who will basically stay longer, stay there for multiple years. And this is how they have this profit margin. Xerxes has exponential growth, doubling in size in 2 years. There is a young entrepreneur in charge who does not like lawyers. Xerxes just hired your law firm, YLF, to represent it. So you are now the lawyer. You are Morton. Morton is indeed the transactional lawyer in New York at YLF. He's working on fund formation, including new offering documents and LP agreements. But Morton is looking over the data. He's looking over the history of the company, and he has questions. He, for example, is wondering, as he is tracking certain names from one year to another to spot check, why some of the names are missing in later years Yet, the turnover is reportedly low. In addition, Morton notices that there are increasing general reserves that are established in later years without any clear need for them. Morton is worried. He has been told that in the early years, the company was handled by inexperienced staff and the records aren't accessible. He asks to see the highly confidential algorithm, the one that gets the tenants in there who will stay a long time. He is told it is a highly confidential trade secret and he is not given access. He is told that there is a CPA firm that audits the books, but he's never heard of the firm. At the retreat, he runs into one of his partners in another office who says she is handling tenant dispute litigation for the company and it's been challenging. Another partner in the same law firm says that an investigator for the Office of Fair Housing and Equal Opportunity has been asking the company for information about the racial composition of the applicant pool. However, despite these concerns and not being given access to the algorithm, Morton has not been able to identify something that has been told to him that he knows to be untrue or believes to be untrue. Morton believes, tracking the negative assurance letter he must sign in connection with the offering, nothing has come to his attention that has led him to believe that the offering documents contain false statements or material facts or omit a material fact necessary to make it not misleading. So put yourself in Morton's shoes. And John, let me ask you to kick this off. What is the ethical framework for answering these questions for Morton and the law firm?
Thank you, Heather. Let me start off with saying that the ethical issues here are, at least the ethical framework is relatively straightforward. And there are very few lawyers in major law firms, and I suppose I've handled 25 securities fraud claims against law firms, and fairly significant size. I don't know of a single one in which the lawyers have been deemed by a bar disciplinary committee to have violated the ethical rules. Nevertheless, it's important for us to understand the rules. The real risk here is civil liability risk, and the civil liability leverages off of alleged violations of the ethical rules. So first, let's talk about the ethical guardrails. The basic rule is that a lawyer cannot assist a client in what the lawyer knows is a crime or fraud. Obviously, what we're concerned about here is that there's an underlying fraud in the securities, the sale of these securities. And that's Rule 1.2D of the model rules, adopted now in all jurisdictions in one form or the other. Know is a defined term. Know in the model rules means actual knowledge of a fact. It's far more than suspicion, it's far more than negligence, it's more than recklessness. Some courts in other contexts have found that willful blindness is the equivalent of knowledge. What is willful blindness? Willful blindness in criminal cases comes up where somebody knowing that there is, or expecting that there's bad information in a book, doesn't look at it. That is the definition, the classic definition of willful blindness. So if the lawyer knows that something's wrong and doesn't look, that is essentially what the problem is for potential violations of the ethical rules. So one crucial concept, if you come away from this with 3 or 4 ideas, then my comments will have had some success. One crucial concept is to keep in mind that the ethical rules apply to a lawyer. They don't apply to a law firm. So when I say that Morton had to know that there was a fraud to have violated the rules, I'm talking about Morton. If you look at each person individually, you don't talk about Morton and Jerome and Sally and then aggregate all their knowledge in one artificial consciousness like a law firm and say, did the law firm know? This is a very common, almost universal mistake in how people look at both the ethical rules and the principles of civil liability, to which I'm going to move right now. So, and I will say that here's how they put together the cases against lawyers based upon these concepts. And there, I think I've got an article called Collective Intent. So they put together these cases by essentially saying that facts came to the attention of multiple different people in the law firm, and those facts, when put into a 100-page complaint, demonstrate that, quote, the law firm knew that there was a fraud. And that is not legally precise. It's very hard to get judges to understand that, particularly state court judges, if you get a 100-page complaint with all of these facts. But the fact is, in order to establish a violation of an ethical rule, you look at the thinking of the one individual. And in order to establish a violation of aiding and abetting securities fraud, which is what we're all worried about here, you have to think about the thoughts and knowledge of one individual, not what everybody in the law firm knew. And so I think I have an article in this materials about collective intent. It's really interesting to read about it and think about it. And when you step back and you say, of course, that's got to be right. Because if we had a lawyer on the East Coast who knew something, and a lawyer on the West Coast, and a lawyer in Brussels, and we tried to put all their facts together, it would be unfair to then call the law firm as having the knowledge of a fraud. So what happens here? Lawyers leave themselves exposed to allegations sometimes of fraud. And how do they do it? They do it because they don't recognize the risk. They don't recognize the risk of the particular lawyer has with this client. So how do you avoid the risk? I have, I think, 7 questions. I'm going to take some of the questions and put them together for economy of time. Okay, how do you reduce the risk? Because realistically, major law firms have almost never been hit for an ethics violation in a securities case. Okay, and I'm not saying it's because the disciplinary boards give them a pass. That's not true. I think disciplinary boards are out looking for major law firms in today's world. I think they're out looking for them. But it would be professional suicide for somebody in a major law firm knowing that there was a fraud to continue in the securities filing. So when you step back and you say, of course he didn't know, of course she didn't know. But they left themselves exposed. And how did they leave themselves exposed? Well, they had the wrong client. I mean, I'm trying to think of how many, I probably had, say, 80 or 90 cases, over $30 million in legal malpractice claims, serious legal malpractice claims. And most of them were what I would call bad client cases. Somebody took the wrong client. It was a high-risk client. They pushed you along, they pushed you along, they pushed you along, and then finally you found yourself in a terrible situation. So how do you avoid bad clients? One of them, the basic way to do it is the intake process. So I developed over years, and I have a kind of an empirical analysis of what the highest risk clients are in securities cases. And I'll just run through the 7 issues very quickly. Privately held clients, young, growing, rapidly growing company, number 2. Number 3, financial or securities-related assets. Number 4, dominated by one or a small group of individuals. Number 5, usually has an unusual business strategy, which it shields as a trade secret, which is what we built into this hypothetical. Number 6, has an abusive attitude towards lawyers. It's very interesting. That's what happens in many cases. They abuse their lawyers, they yell at their lawyers, they try to browbeat their lawyers to keep their lawyers from asking more questions like, how could you be so stupid? Or you're doing this just to earn more fees. But what they're really trying to do is keep you from looking too deeply into the company. And number 7, management lacks public company experience. So let me turn now to the negative assurance letter, which is a negative assurance letter is very interesting. I've litigated negative assurance letters. And they are, at its core, a negative assurance letter is, probably learned hand said, a state of a man's mind is like the state of his stomach. It's a fact. A negative assurance letter says, I do not believe that there has been a fraud in the offering materials. That's the substance of the letter. It is the flip side of 1.2D. We just talked about 1.2D, which is the ethical rule, that says if you believe there's a fraud, you can't do it. So the negative assurance letter, looked at purely from a logical standpoint, is exactly the flip side. So what's the big deal? What's the big deal about signing a negative assurance letter? It's a big deal. It carries a lot of baggage. A lot of judges don't understand negative assurance letters, honestly. Particularly, take a state court judge who's never seen a sophisticated securities litigation before and put a negative assurance letter in front of them with a 200-page complaint and 120-page offering materials and say there's no question of fact, and they're going to go, oh, right, motion to dismiss denied. I'll talk to you after 3 years of discovery. That's the problem. The negative assurance letter is sometimes seen people as a 10b-5 letter. The lawyer is promising there's no fraud in this transaction. It doesn't say that. It doesn't say that at all. But a negative assurance letter has a heightened degree of risk for a couple of reasons. One of them legal and one of them probably kind of historical. Legal is a negative assurance letter, you're actually speaking to the investor because you're writing a letter. In all other circumstances, you're advising the issuer here, and the issuer is speaking. When you start speaking to an investor with a negative assurance letter, that heightens your liability under the laws, many state laws. And secondly, I just don't think judges understand negative assurance letters. And I'll take one little, staying still within my time, I have one little story. I was on a panel for the Working Group of Legal Opinions, and I had a very distinguished retired judge on the panel. This is about 10 years ago in New York. And we were going through a letter in which he had written a very famous opinion, which you all know, but I won't mention it. It's a very famous opinion. And he said, when he and I went through the letter, I said, sir, I don't understand how you could interpret that letter to cover this conduct. And he said, and I think they probably have a tape of it, he said, well, if I interpreted the letter literally, it would be almost meaningless because it's nothing more than your ethical obligation. And I thought to myself, oh my gosh, here is a superstar judge, and he is interpreting the letter far beyond what it was intended to be and what we all thought it was going to be because he thought he had to give meaning to it. And of course, if you know, your ethics committees and your opinion committees spend weeks working through these different issues and trying to get the words just right, and he just blew past them. So what does it come down to? What are the allegations against you likely to be? So I'm going to go right to the second question, unless you would like to. Is that okay? Let me go to the second question. What are the allegations against you likely to be? They're going to be by an investor, and they're going to say, they're going to assert claims that you knew that there was a fraud and you aided and abetted the fraud. Okay? They're going to basically make an allegation of secondary liability against you for knowingly aiding and abetting a fraud or aiding and abetting a breach of fiduciary duty. They may also, in some jurisdictions, so the concept of privity is kind of, at common law, means a contract. It says you have privity of contract. Well, the concept of privity also applies to lawyers. In many jurisdictions, you cannot be sued. You can be sued by anybody, but nobody can establish a claim against you unless they're your client. It's called privity. Now, that has broken down around the country in many jurisdictions. But one of the ways in some jurisdictions you can sue somebody who is not your lawyer is by alleging a negligent misrepresentation by the lawyer. So the two ways that they'll come at you in a civil case, if you're the lawyer for the issuer in these circumstances, is aiding and abetting a fraud, that you knew that there was a fraud and you went ahead and did it anyway. And the second one is You negligently made a misrepresentation. And that's really a question that goes by state law from state to state. And there are hard cases to defend because what happens is they put together this massive complaint. The plaintiff's lawyers are excellent in these cases. They put together a massive complaint with a lot of facts and say they knew this and they knew that, and they put it in front of the judge and say, and I have to file a motion to dismiss, saying there's no question of fact. And you look at the judge going, oh my God, you got to be kidding me. Most of my cases have got a 4-page complaint, and even those I don't dismiss on a motion to dismiss. This is a 100-page complaint. And you say there's no question of fact, and if they get past the motion to dismiss, then you are in a situation where it costs you a fortune to defend the case, and you're also get a big professional black eye. That's why when we talk about trying to avoid these claims, you cut them off first at the intake level by not taking the bad clients. And second, when you have concerns about a client, you have to be aggressive in looking to see what the problems are, pressing the client for answers. So what the plaintiff will do is to try to aggregate the knowledge of all the different lawyers. And that's why we kind of mucked it up in the hypothetical. It's really interesting because we're really looking at Morton's knowledge. That's what we should be looking at. But Morton talked to these other two people. So did he really have their knowledge, or didn't he have their knowledge? Kind of an interesting way of looking at it, and it would be an interesting question. So let me move on. I have another 5 minutes, I think. So let me move on to just a couple other issues. Are there new ABA pronouncements? Yes, there's an ABA opinion on this that came out, formal opinion, 491. The release date is April 29, 2020. And it's seldom that I could summarize it for you, but they have 2 or 3 sentences that are really very, very cogent summaries. So just let me read the sentences. It says, the opinion is entitled, Obligations under Rule 1.2D to avoid counseling or assisting in a crime or fraud in non-litigation settings. It reiterates that the litmus test for violation of 1.2D is knowledge that there's fraud, knowledge, okay? But here's what they say. Even if information learned, I'm going to crib a few words out, even if information learned is insufficient to establish knowledge, under Rule 1.2D, other rules may require the lawyer to inquire further in order to help the client avoid the crime or fraud, to avoid professional misconduct, and to advance the client's legitimate interests. If the client refuses to provide the information necessary to assess the legality of the proposed transaction, the lawyer must ordinarily withdraw. Okay? So, and then it goes on to say, that basically, if you read it, it says, you got to ask the questions, or you should ask the questions. It doesn't say, if you fail to ask the questions, you will be deemed to know that there's a fraud. It doesn't say that. But what it's trying to do is push the lawyers to ask questions, and particularly in a situation where it's your client that has the information. It's a lot easier if it's your client. If the information is, what does an algorithm mean? Or what's a prediction? I mean, I don't know how you answer those questions. But it is, I think, a way of saying that a lawyer needs sometimes to go out and ask their clients the hard questions. And it says, in substance, if you don't get the answers, you may resign. Now, you always had that opportunity under Rule 1.16, which is the rule that says you can resign as long as you don't unduly there are a number of different elements to it. But it is a reminder to the lawyers that that's what they want to do. If you read 491, opinion 491, it's an interesting opinion. It really wasn't designed for you securities lawyers. It wasn't. It was designed primarily for the lawyers who were representing clients who were trying to either engage in money laundering, tax fraud, maybe even moving assets abroad, things like that. That's really what it was designed for. But the language, I think, is informative for all of us. But in the end, does it change the standards? And I would submit to you it doesn't. Because, and if you look at the commentary, and I always try to pick out everything good for lawyers, right? I mean, that's my job. I'm trying to be here to help you and defend you. It says, the text says that the need for further investigation is triggered when the lawyer has, quote, knowledge of facts that create a high probability of fraud. That's a high standard, okay? That's a high standard. So there are a number of ethical issues that are discussed in 491, but really forget it, it's all kind of window dressing. It really gets down to this issue. They're pushing you to ask questions. So I have one other issue I'd like to, do you want me to go on to handle that?
Please.
Okay. So are there any SEC or other, any SEC enforcement actions or regulations that might be of interest? You know, I think we've all kind of, in one way or another, tiptoed past 17 CFR section 205. And for those of you who don't live in this area like I do, after the 2001, 2002 meltdowns, the SEC adopted an up-the-ladder reporting requirement, which in many ways, and if you listen to Chief Justice Seitz' very interesting luncheon speech, he talked about how federal and state law in the corporation world were trying to find an equilibrium. The same thing is happening with the SEC. They said, wait a second, you know, the ABA model rules have a very low threshold for lawyers to kind of blow the whistle. So we're going to change and we're going to incorporate into the rules for lawyers appearing and practicing before the commission a different threshold. It's kind of the first, when you think about it, nobody sat back and thought about it as far as I know. It's the first time that we have grappled with the notion of a nationwide ethical rule. And because you SEC lawyers, or your securities lawyers, you don't practice just in one state. Your issuers are all over the country, right? And so the SEC has adopted this rule, and it says, under the Supremacy Clause, we override state law. And it is similar to the ethical rules, but it has a lower trigger, because the ethical rules say you've got to know there's a fraud before you do something. The SEC rules say there has to be a material violation. Then the material violation standard is kind of screwy. I don't know, somebody had too much coffee when they wrote it or something. But it's basically, it says it doesn't have to be more than 50%. I think what they're saying is you don't have to be certain. You don't even have to conclude that it's likely that there's a violation to trigger the up-the-ladder reporting rules. So 17 CFR section 205 is a very interesting conceptual standard because, as I say, it's the first attempt to adopt a nationwide ethics rule. It basically has not been the basis of civil or other claims by the SEC or really anybody else except in a few extreme cases. But I would urge you to keep attention to it because the SEC has become much more aggressive in these circumstances. So I really have addressed all of the issues that I feel are important. I would say in the securities fraud cases that lawyers are, what happens to lawyers is that 1 out of 1,000 clients, I'm picking an arbitrary number, are engaged in fraud. And so in your career, you probably are unlikely to see one. And if you see them, you'll only see them once, and they'll get you with a left hook because you will never see it coming. And that's where good lawyers end up getting dragged into these cases little step by little step, and pretty soon they find themselves too deeply in the case and they can't quite figure out how they got there and how they get out. And they need the help of good people like Carol, who's inside counsel, to help them confront clients and ask the hard questions. And if necessary, call a timeout. Say, look, we're not going forward until I get some answers. Thank you.
Thank you, John. That was excellent. I would like to direct you to the materials that John submitted. I'd urge you to take a look at them because they are excellent. As John mentioned, there is an article about collective intent, which he talked to you about. There's also an excerpt from his book, Corporate Counsel Guidelines. He has rights to share excerpts from his book, and he's elected to do that with you. It's very valuable. And he has essentially a compilation of securities claims against lawyers taken from pleadings in real-life situations that I found to be a very interesting read. You know, the one thing I would add before we move on to our next speaker is I just like my three panelist colleagues here, am in the business of defending lawyers and advising lawyers. And I'm always really interested when I defend a corporate lawyer, a corporate securities lawyer, a corporate transactional lawyer in a case involving investor losses, what the lawyer has done in terms of client intake. And John's point in that regard is really important. I also think it's important to look at risk reward. I have, I think, 5 or 6 cases under my belt where my client, the lawyer, has been hit with a huge aiding and abetting lawsuit where there's a Ponzi scheme, huge investor losses. There's something, a negative assurance letter or otherwise, that the investors purportedly relied upon in making their investments. And my lawyer client has charged as low as 4 figures and many times under 6 figures. Risk reward. What are you being paid for the risk that you are taking on? It's a little cynical, it's a little harsh, but to be hit with a $100 million aiding and abetting Ponzi scheme allegation for your $25,000 fee is not going to pencil out for you very well. Thank you, John Villa. You were excellent, and thank you for coming from DC. So now we're going to turn to Dave McGowan right there, and I'm going to tell you a little bit about Dave's hypothetical. This has to do with entity formation and entity representation. So here's our hypothetical. So A and B start a wallet venture. A does the coding, B does the marketing. They sign contracts before formation. They consult with C, C is the lawyer, regarding formation of a Delaware corporation. They disagree on equity investment, equity allocation, very common disagreement, and they bring in a third investor. There is an unsigned engagement letter that says C represents the company. The client is defined in the unsigned engagement documentation. C then sends a letter to A, B, and D. These are the investors and the principals, stating that her relationship, the lawyer's relationship with Old Co, is terminated, and she now represents New Co. She does the formation work for New Co. She gets equity and crypto as a fee. That's a whole nother seminar, taking crypto as a fee.
Hey, you told me to put it in this one.
So nice succinct typo there, very interesting, Dave. Let's kick it to you. Let's talk about who C represented, what the rules say about that, and what that means. Dave McGowan.
Good morning. How y'all doing? I apologize to you that we get to look at the ocean and you get to look at us. We got the better of this deal. I'm going to talk about new companies. So what John was just talking about, you typically associate with more mature companies, registered securities, though not exclusively. It can come up anywhere. And I want to do a little bit of bridging between what John was talking about and the hypo that Heather was just outlining for you. When John was going through his risk factors, dominant figure, new company, rapid growth, I thought Fairchild, Intel, Twitter, Google, Facebook.
Hates lawyers.
Hates lawyers? We won't put that list on. It sounded to me like Silicon Valley. And I'm like, shy people don't start companies. People who start companies view lawyers as, what's the word I'm looking for? Overhead. We are not revenue streams. Unless you're a patent assertion entity, you're not bringing the money in. You're a cost to be minimized. That's apropos of kind of what Heather was talking about in terms of what's the risk-reward ratio. You don't know whether they're going to pop. If they do pop, I've seen, sort of convention, a lot of people say, we'll clean it up then. But the ones that do pop may have messy histories. So I want to talk in a timeline sense and divide this topic into 3 periods of time. Period of time number 1 is when some bright person has an idea and they get going. This is almost invariably going to happen before they contact a lawyer. They're going to be sitting on their porch in Palo Alto. 2 grad students are going to show up, say, I've got an idea. They're going to walk away with a $100,000 check. Some people recognize that story. It's true. No lawyers yet. No company yet. Who owns the asset? That's period of time number 1, and I start there because that is the business before it's a legally recognized form other than as a de facto form. Period of time number 2, the lawyer gets involved and everyone's happy because they love talking to lawyers. Next to going to the dentist, it's the thing they like most. There's a period of time in which you negotiate the formation documents, you sign them up. Period of time number 3, the company goes forth. The probability that the company succeeds very well is low, just as an empirical matter. If the company doesn't succeed, there's not enough to fight about, so you don't get a lot of civil suits. The rules don't change. But if the company does succeed, you've got this history. And that's where risk comes from. So I want to distinguish a couple of things. John was talking about the rules in civil liability. He's absolutely right. And on this topic, dealing with formation, the rules are really, they're not even quite the backboard relative to the rim. They are the outline of the field, but 2 things that are far more important as a practical matter and relevant to civil liability are common law contract principles, because the rules of conduct, the disciplinary rules, don't really tell you what formation of an attorney-client relationship looks like. They give you a couple of hints of what to do, but they don't actually give you those rules. They're parasitic on common law rules. The other thing is custom. And within custom, there's a distinction between repeat players and non-repeat players because of the reputational effects. When you look at this in a dynamic life cycle way, the thing that I like to advise people when I get these calls, if you get them early enough, and this would be true, I think, of John's example as well, which I'm going to steal from Daniel Kahneman. You may have read a book called Thinking Fast and Slow, but it's a wonderful idea. It's called a pre-mortem. A pre-mortem is a thought experiment that says, imagine things blow up and you get sued. How is that likely to have happened? What will they look at and point to? It works pretty well if you're wondering whether to sign a letter. It works pretty well if you're trying to model your formation practice. So let's start with time number 1. In my hypo, A and B get together. It could be anything, obviously. They have an idea. They're complementors. One of them's got marketing expertise. One of them's got product expertise. In this hypo, they don't have a business person who's acting as sort of a advisor, but that's fairly common as well. They get some contracts for future business. At this point in time, what are they legally? You could call them a de facto partnership. And the reason that I mention this is that prior to formation, are you going to take the position that you represent the entity, if you are brought in as C in this hypo? Are you going to take the position that you represent the entity and the individuals? Are you going to take the position that you represent the individuals only? Nobody ever does 3. Overwhelmingly, firms that engage in new company formation practice have the view that they represent the company. It's the default for entity representation under Rule 113. It's the way the firm works. It's what you want to do because going forward, that's where the work's going to come from. In academic literature and in some case law, a question comes up that's a basic chicken and egg question. How can you represent the company if there is no company? The model rules, ABA Rule 113, has a comment that says when you represent an entity, you represent the entity as such, not any constituent, and the entity as such doesn't have to have a formal form, so it can be a sort of de facto entity. that works. A and B in my hypo are not sitting there pondering what kind of entity are we. If you start engaging with them and they have a business that has any kind of operations whatsoever, the position you're going to want to take going forward is you represent the entity. If you don't take that position, then it's not clear whom you would represent, if not the two individuals. Representing the two individuals plus the entity is something that firms typically avoid for conflicts reasons. The way they avoid it is with engagement letters, such as the one that I posited in the hypothetical. The engagement letter in this hypo and the engagement letter in most cases I see come later in the process. It's not the first thing you do. It can be, but it's fairly typical that it will be part of the documents that get executed when the transaction has some funding lined up and when you know it's actually going to occur. I want to start with the first period of time, though, because it's important from the outset to bear in mind what the legal rules from a civil liability risk point of view are. If you want to represent the entity, which is the default, you need to understand how does representation work. Representation works by virtue of contract law. In this case, it means, generally speaking, implied contracts. So the perspective you want to take on time period one when you're dealing with people and they don't have an actual form is this. What do my actions imply relative to the question whether I have undertaken to represent the founders? As a matter of law, there is no representation absent an agreement. An agreement needs reciprocity. It needs not subjective mutual understanding, but it needs an undertaking by the lawyer and an undertaking by the putative client. If you have, and most people will at some point, use disclaimers saying, we're here to represent the company, we don't represent you, that would be text that is inconsistent with representing the individual founders. If it's an implied in fact contract argument, which is a very common argument to see made when these go into civil litigation, text is part of, but not the entirety of, the plaintiff's case. Because implied in fact contracts can have some text and some conduct. So what you're actually doing in time frame number one, you're talking to these people. Is your conversation privileged? Your position's going to be it is. Who owns the privilege? The client owns the privilege. Who's the client? The client during time one is gonna be the entity, however you want to characterize it under state law, de facto partnership, or whatever you want to call it. That's going to have significance when we go forward, but from the outset, it's important to bear in mind that you're going to be viewed retrospectively with respect to the question, did your conduct evidence an undertaking to represent folks individually or to represent an entity only?
Dave, could I ask you a question here?
Fire away.
So we all know, well, anybody who's involved in representing lawyers knows that oftentimes with the entity, the individual officer or member or partner or shareholder will say, hey, you represented me. I thought you were my lawyer. And then you go to the engagement documentation, and indeed it says that you only represent the company, but the individual denies knowledge of that.
Right.
Perhaps they didn't even see the document. And then, as you just said, they claim a course of conduct which evidences an attorney-client relationship. So I'm just curious, what are a couple, in your experience, practical tips for avoiding that type of risk? How do you get across that you only represent the entity and avoid that lawsuit by the individual?
Well, I teach law students, so I can tell you from deep personal experience, you can say something. You can't vouch for whether it's heard. So when the claims come up, as Heather's pointing out, somebody's going to say, and it only happens when the company pops, somebody's going to say, wait a minute, I thought you were my lawyer. And then there's going to be something that follows that. part of the problem with the new company issue is avoiding the risk. It is very hard, because it's dynamic and you're going to go all the way through formation, it is very hard to say that if I tell you up front, I'm going to represent the entity, I don't represent you, and it's verbal, that's going to stick. And the reason is simply this. Although the standard is that the plaintiff, in a case where they say the lawyer represented me individually, needs to show assent, needs to show a contract, people will tend to give them disclaimers. Fine, you give them a disclaimer on day one. I'm going to represent the company, I don't represent you. You can do it verbally, you can do it in writing. 2 days later, they ask you a question and you answer it. In what capacity are they asking the question? In what capacity are you answering it? This may sound a little bit nihilistic, but you have to remember all of this is going to be done through hindsight, and you're going to be cherry-picked on companies that succeed where you have disgruntled folks on the front end. There's no real way to immunize yourself against the possibility of selective recollection assisted by plaintiff's counsel ex post. Did I put that politely enough? Y'all with me? So you can do some things, and one of the things that I think Heather is pointing out, and quite rightly so, is part of what you're doing is trying to get a deal done. Part of what you're doing is building a record, and those two will be in tension sometimes. In John's example, you're asking questions. If you get answers that you don't like, or you get answers that are really alarming, you say, I'm going to withdraw. And maybe you say it's mandatory withdrawal. And the client says, you withdraw, the deal craters, I will sue you for the value we were going to raise. So now you've got civil liability risk on both sides. That's true here as well. So you can put in disclaimers, and that is helpful. I cannot tell you it's a silver bullet. So part of what I want to talk about is managing that risk and custom. But let me go to time period 2, which is actually forming the entity. In this example, what we have, and this is taken from an unreported California case, we have a disagreement among founders whether a third funder is brought in. The third funder pairs up, D pairs up with B. They split off and they say, we're just tired of dealing with A. Anyone ever have anything remotely like this happen? It's never been heard of in the whole world, really. I'm sick of you. You go stand over there. We're going to develop a new company. The first one was called Palladium. This one's Rhodium. We just love these rock things. Fine. We now sign up an engagement letter, and the lawyer sends to the constituents of the first company, NewCo, an email saying, I don't represent you anymore. I'm going to represent the new company. Hit a pause button there. If it is the case that at time period 1 there were operations, you got your $100,000 check on the porch in Palo Alto, and you're taking the position that that's a business entity of some de facto sort and you represent it. The founders then have a disagreement. One of them drops out. The two new ones say, fine, we'll just set up a new entity. We don't need to deal with that person. And you go to represent the new entity, which is going to take over the contracts negotiated by the time period 1 entity. Are you acting adversely to a former client on a subject substantially related to your prior representation of the former client? Strangely enough, and this is the reason I characterized this hypo this way, you want the answer to that to be yes, because the alternative is you are acting for the two individuals. A is going to say, I have a claim either way, and it's a question whether it's a personal claim or an entity claim. But the dynamic nature of it, when people start falling in and out, you need to have a consciousness at time 1. You're going to want to say, I represent the entity. If the entity metastasizes and you need to set up a new one because the old one becomes too empty, it presents a conflict issue at the entity level. It is typical, I think, for people to assume, and I want to talk about custom for just a second. Custom, in my experience, at least on the West Coast, and I think this is true on the East Coast as well, is that people will assume, based on a case called Jesse against Danforth, that when the entity is formed, it will accede to any client rights that may have been created prior to formal formation. There's a case that says that. it fits very well with custom because the reason people start these ventures, the reason they come talk to lawyers, is with a view towards establishing an entity. That makes a ton of sense. There's not a definitive California or New York case adopting that. There are academics who don't like that because they think it's untidy. They think it doesn't answer questions, for example, who who speaks for the entity before it's formally formed. So, although that's custom, it too is not a silver bullet. So I've got 3 minutes, so I'm going to cut to the chase. Time period 3. In my hypo, when lawyer C goes to time period 3, lawyer C has an issue because lawyer C is now representing a company that's essentially trying to take the assets of a prior company. The main takeaway, and apropos of Heather's risk management question, is that taking the pre-mortem idea, you want to look at your documents and you want to look at any given transaction and identify the touch points that are likely to become the basis for an argument that there's an implied in fact agreement. The touch points tend to be places where an individual who you're dealing with on behalf of NewCo has both a company interest and a personal interest, whether it's an assignment of IP, whether it's an employment agreement, share purchase agreement, whatever it is. Because it is a fine line to walk saying, we are going to be doing this contract, we are representing the company. It is a contract between you, CEO to be of the company, and the company. You're going to sign both sig lines. Anytime you see somebody signing both signature lines, that's a touch point. I'm at the end of my time. I'm not going to talk about crypto and equity as fees, other than to say they're treated as transactions with clients. Be very careful. Make sure they're fair and make people get independent representation if you can. How's that?
Excellent.
Thank you.
As
Heather's
always,
very
Dave.
good at keeping me on time.
Well, I have the best panel ever here. So I will comment before we move on to Carol for our final segment that we've had a lot of discussion about risk, and I hope you've picked up some practical tips about how to avoid risk. Of course, unfortunately, risk comes in many forms. In your practice area, you have risk from the client. We just heard about risk inherent in the individuals associated with the entity that you represent. John told us a lot about third-party risk involving investors. We heard some great tips on that. And I'm just curious, a question came to mind, John, I just want to ask you before we move on to Carol. When you identify the risk during the course of the engagement, maybe you make a determination that you're not going to withdraw, right, even though you know there's risk. What do you think about the concept of an internal memo within your law firm, something that may be work product, at least to begin with, to document your reasons for staying in the engagement?
Well, that's a very tough question, and I'd be delighted to hear from the other panelists too, because it's a total judgment issue. But I'd rather not have the memo, and the reason for it is if nothing happens and there's no fraud and everybody's happy, the memo is pointless, right? If something goes wrong and you miss things, they're going to hold up the memo and say, look what they missed. They saw 19 issues and they made the wrong call. And I think it's just going to look terrible. And you're better off trying to explain it in a summary when the issue comes up. So my judgment would be, don't do a CYA internal memo. You're almost never going to get it exactly right. And even if you do get it right, in the sense that you balance everything, obviously when something goes wrong and there's a fraud, somebody's going to say, oh, come on, give me a break. He must have thought it was terrible, otherwise he wouldn't have done a 28-page memo.
Right.
So I think that it's a strange world, but writing it all down to try to capture it, to prove that you're doing your best, will come back to haunt you, my judgment.
I think we're nodding our heads on this end. Yeah, everybody's seeming to be in agreement on that.
Many years ago, I had a case, no names mentioned, where the transactional attorney was assisting the client with the offering. The relationship went sour, and the lawyer wrote a withdrawal letter to the client saying, here are all the red flags, and plus you're a horrible client. Before he sent the letter, the client came back, apologized, said, I really want you to be the lawyer, made a big deposit, and the letter was never sent. The company ended up going into bankruptcy. A trustee took over. The trustee demanded the file because now the trustee holds the privilege, and that draft letter was in the file. You can imagine that was Exhibit A. But I think it kind of goes to John's point. Always think carefully about what is in writing, what is not in writing, as you manage the risk in your profession. Now, talking about risk, I think we have a very, very interesting final topic here, internal investigations. This is like the sexiest topic, I think. Carol has made it even more exciting by presenting us with a Wizard of Oz hypothetical. So Dorothy, in-house counsel for ODDS Enterprises, a multinational cryptocurrency exchange. We just can't stay away from cryptocurrency here. Calls outside counsel Glinda, a partner at the Kansas headquarters office of a multinational law firm. Dorothy reports an anonymous whistleblower calling himself Coward, who claims that the CEO, Professor Marvelous, is engaged in an ongoing fraudulent scheme involving an affiliate, Pumpkin Research, located offshore in Pumpkin Land. Now, Dorothy and Glinda decide that an internal investigation would be appropriate. So, Carol, you're now in charge of this internal investigation. Who is the client? What conflicts of interest should be considered up front?
Well, so I don't know if I'm going to be Dorothy or Glinda, but I like the costume for Glinda better, so maybe I'll go with her. But so first of all, we need to decide who is the client going to be. Is it going to be the company? Is it going to be the officers and directors of the company, a committee of the board, or maybe include the affiliate, Pumpkin, or not? Maybe also include the whistleblower or not, and probably not include the alleged wrongdoer, the professor and CEO. The important thing here is to consider what's at stake in the investigation, and most likely we're going to want to have one client here rather than multiple, and it's probably going to be the company or a board or a committee of the board that would be the appropriate client. As in terms of conflicts, Glinda is their regular outside counsel. She is their corporate lawyer. And one thing they should think about is, does she really have the expertise to handle what looks like it might end up being a white-collar investigation? Another thing is, if she is their corporate lawyer, does she have a conflict in terms of potentially being required to investigate her own work? And we're going to have to look very closely at what she did in her prior work and make that decision. We also want to think about whether Glinda is the right person to handle the investigation from a credibility perspective, because if she is going to be the longtime company lawyer talking to regulators, DOJ, SEC, that may not be optimal for the company depending upon what ends up being at stake. So probably in this kind of a scenario, they're going to want to get an independent attorney to do the investigation. And in my hypothetical, I named her Ann T. M. Auntie M. So she's going to be our independent counsel. We're going to want to define in the engagement letter also the scope of the investigation. And that is going to be very important because we want to know, is this going to be a situation where you're just doing an investigation, or you're also going to be giving legal advice? That's very important to the privilege, and we'll talk about that a little bit later as we go along. So I think we can move on.
And let me ask you this, Carol, before we move on. I have one inquiry for you.
Okay.
There's also the question of whether there should be an investigation. So let's say you're the corporate lawyer. Is it your ethical duty to advise on that issue, whether an investigation is in the best interest of the company? And we know that many investigations end with a writing, a big, long document that reveals the details of the investigation. Some don't. Some end up with a verbal report to the board of directors. What is your thoughts on this issue from an ethics perspective?
Well, first of all, as to whether you should do it or not, if you are regulated, or if you think there's a serious opportunity to become a DOJ target, then you're going to want to do an investigation because you do have a duty to mitigate serious misconduct that may, in this case, actually be ongoing. That's the hypothetical. And as to whether you do a report or not, I think that's very case specific. I don't think you can decide at the very inception of any investigation, we're doing a report or we're not doing a report. Probably you're going to want to do it and then decide, but I think it's very common to not want the whole thing documented in writing for many of the reasons we were just talking about in some of the prior hypotheticals and what John was mentioning. Because if there is an investigation report, it can be hard to control. It can get leaked. We've seen all kinds of things leaked lately. And you are going to have constituents that will feel entitled to see it, feel entitled to information about it that you may not want to share it with. So I think that's something that has to be considered very, very carefully. Heather, you were mentioning involvement in some situations where there can be an epic battle over the report. And if there is no report, if there is no written report, maybe that is not going to be such a battle.
In San Diego, we had a case with a leaked report with a purported doctored footnote. So there's also the question of who gets your hands on your report and what can be done with that report. Really interesting issues. So continuing on with the hypothetical, we're back in Oz. Once council is on board, Dorothy recommends that she speak with two members of the board, Mann and Crow, who may know the true identity of Coward. Overseas lawyers for Pumpkin Research also reached out to Dorothy about a JDA, a joint defense arrangement. Marvelous remains sequestered in Amethyst City. His latest tweet said, "People believe anything." Dorothy would like to hire her Uncle Henry's PR outfit to help with the PR blowback. And meanwhile, regulators, foreign and domestic, are reaching out for information offering confidentiality. A lot going on there, Carol, but what are the ethics issues?
Well, so first of all, Dorothy is going to have to be very careful about any implication of joint representation if she is going to reach out with to the members of the board. And that may be better done by the outside counsel rather than in-house counsel. The public relations disclosure may waive privilege. So she does need to be very careful about that as well. There is some case law, at least in California fairly recently, that says that unless it is necessary to the litigation to have a public relations consultant involved, that is potentially going to be a waiver of attorney-client privilege. So the case law that I wrote an article about this, it looks very difficult to make it necessary to have a public relations consultant in connection with litigation. That's a very high bar to meet. As far as the common interest privilege or the information sharing with the affiliate, the recent cases suggest that if there is a situation where there may be an adverse relationship between parties who want to share information, then there is no common interest privilege. So that's always very hard to tell. I think an investigation is somewhat like a kaleidoscope, and it keeps twisting and turning, and the picture keeps changing. So you do want to be very careful about sharing any information. The affiliate is also located in a foreign country, so you do want to consider attorney-client privilege issues and recognize that foreign jurisdictions, depending on where you are in the world, can see issues of privilege and confidentiality very, very differently from the way that we would normally regard them in the US. And that's something, because this affiliate is located offshore, that should also be really carefully taken into consideration. And lastly, on the disclosure to regulators, I would take a wait-and-see attitude on that, especially at the initial stage of any investigation. Again, there's a lot of case law on this that is somewhat mixed, but you're going to be met with the argument that a disclosure to the regulators would be a waiver of attorney-client privilege. So you're going to want to be very careful about what you do disclose. If anything, you can look at the DOJ policies on this and consider whether it's feasible to make a disclosure of facts rather than analysis or work product. You can try to do that without documentation and do it in a conversation in order to cooperate with the regulator if that is in the interest of the company. All of this, I think, is very case specific and depends upon the individual circumstances and what is coming out over the course of the investigation. And even as you're going through the investigation, it is sometimes hard to tell where things might end up. You think it may be going in one direction, and a new witness can send it in a completely different direction. So I think that all of this it requires a lot of judgment, and that's where having someone who's very experienced in doing investigations like this can be very, very beneficial. They know how to handle the regulators. They know how to handle the nuances that can come up, and can guide the company in doing that.
Let me ask John a quick question here as well. Certainly we're seeing in litigation this concept of common interest agreements, the joint defense agreements, the terms are synonymous, are becoming very prevalent in litigation. And obviously here we have a request for such a joint defense arrangement in the context of an investigation. And Carol just gave us some cautionary words about how those play out. Do they really protect? The gist of it, of course, is it's supposed to protect the communications and the exchange of information between the parties to that common interest privilege or that joint defense agreement arrangement. But John, I'm just wondering, from your very sophisticated litigation perspective, how have you seen this play out?
Well, I think it's dangerous to enter into a joint defense agreement in those circumstances for a couple of reasons. And one of them is the courts will sometimes penetrate those agreements and say there was no true joint defense, and therefore the communications are not privileged. I think I always get the names wrong, but I think it's Ryan versus Thomas or Thomas versus Ryan. There's a case in Delaware where they reported the results of the investigation to some directors, and the directors were partially the targets, and that was deemed a waiver because they said, well, it wasn't a true common interest because you didn't have a common interest. And I guess secondly, you just never know where a case is going to go. And there are many times where after a case gets going, you say, well, wait a second, okay, these directors didn't do anything wrong, but they certainly fell down on their caremark duties. They didn't oversee regulatory issues that percolated up. we got a problem with them, and you say, and you're thinking to yourself, oh, I am screwed because I've already entered into an agreement with them where they're my clients. And now I'm realizing that I have a conflict of interest with them. And so it's better to say, look, get your own lawyer, and we're not going to have a joint defense. We're not going to have a common interest agreement until you absolutely know at the end. And one other comment, and it kind of leverages off of the thing that Carol said. The lawyers have a lot of sophistication as to whether or not to disclose it to the government. But the directors make the call frequently, and the directors' modus operandi is disclose whenever possible because it protects me. I'll never be charged with a cover-up if we disclose, and that's sometimes not in the best interest of the company. So it's a really interesting interpersonal dynamic where the directors are kind of stepping out of their role as fiduciaries and thinking about themselves as potential targets of criticism and making judgments that are perhaps not in the best interest of the company. And that's not uncommon.
Thank you, John. In our last 5 minutes, we're going to go over the final segment of Carol's Oz hypothetical. So we have M preparing for several key interviews, starting with board members to seek the identity of the whistleblower, Coward. One asks that M confirm that she keep the discussion confidential. M schedules an interview with Marvelous, aka Blizzard, who remains in the land of ODDS. Following news articles, Dorothy receives additional inquiries from foreign and domestic regulators seeking her report. Let's talk about the ethics issues here, Carol, of which there are many.
Yes, there's quite a few, quite a lot going on here. So first and foremost, the question is going to come up, how should this be handled in terms of the interviews? And you see Auntie M, the outside counsel, is the one who is going to do the interviews. She is going to want to consider giving the party she's interviewing an Upjohn warning, or also called a corporate Miranda warning. And the rule on that, 1.13, says that whether you need to warn depends on the facts and circumstances. And so it goes on to say, where the witness has interests that are adverse to the corporation, or the other way around, then a warning should be given. And so as to the question, can she keep it confidential? The answer to that is going to be no. She has got to tell whoever she interviews, particularly if their interests are adverse, that she represents the company, she does not represent the individuals, that they may want to get independent counsel. She's going to want to be careful not to mislead them into thinking that she is representing them, not to give them any legal advice, and at the same time tell them the discussion is going to be confidential, but it's the company that holds the privilege, and the company is going to do whatever it wants with the information. So the individual being questioned should not be able to make any disclosure of it, since it is a privileged conversation under Upjohn. But the company may decide to use the information and to disclose it to third parties. Certainly the attorney is going to disclose it to the board or whoever else she's dealing with at the company. And they may also need to disclose it to regulators. So the company owns the information in the interview and has control of that. That is quite a lot. You're going to want to whip that into a very succinct warning to the individuals and give the same warning to everybody, but particularly if they are potentially adverse. It can be a challenge to get this across, and you do run the risk that somebody may say, well, so based on what you just told me, I do think I should get a lawyer. And then that would be the appropriate course of conduct to let them go ahead and get a lawyer and decide how to proceed forward. We again have some issues that are going to arise under foreign privileges, foreign confidentiality regulations. So if you're going to be questioning witnesses regarding the affiliate or with the affiliate, then you're going to have to understand how privilege and confidentiality work regarding that, as I touched upon earlier. And then last of all, should you write a report and should it be disclosed? Well, you may get some benefit from disclosing something to the regulators, as we talked about. You may get some mitigation in connection with whatever the regulators have in mind to do with regard to this. But you don't want to make a disclosure that is going to be a waiver of the privilege, because that may come back to haunt you in follow-on litigation such as a class action. So that is it in a nutshell, and I think we covered a lot of issues and we're just about out of time.
Thank you, Carol. That was excellent. I just can't stop myself from offering one risk management tip. We've talked a lot about the peril in speaking or communicating with individuals associated with the entity client. I see it in the litigation context, but there are very simple things you can do to reduce that risk. For example, an email to the individual saying you do not represent him or her and that they should consult with their own client, and an email indicating where the information that you obtain from that individual will go. For example, it will be shared with management in the company. I can think of a lot of pieces of litigation that would have turned out differently had we had that simple email. I also wanted to, as we conclude here, to direct you to Dave and Carol's materials in the that you were provided through this Securities Institute. Dave has a great paper on entity formation, and Carol has a great one on internal investigations that they put together, I believe, specially for you. So now we go to our final slide. This is so you can confirm that we are who we are and we are not imposters. Those are our pictures. It has been a true pleasure being with each of you today. We wish you luck with the rest of the Institute, and we most importantly welcome you to San Diego, where again I am from, and we hope you enjoy our fine city. Thank you.